We have Justice retired Mary Angawa, who's also a past board member of the Chartered Institute of Arbitrators. We have the CEO of the Nairobi Center of International Arbitration, as well as the registrar, Dr. Henry Murigi, and our friend, and one of our members, Mr. Samuel Murigi. It's actually interesting that we are hosting two Murigis in this webinar today. The reason for these talks and the reason why the Institute is critical on having this conversation is because we need to know what is happening in the markets. And these webinars act as that platform where professionals, practitioners, clients, users of ADR mechanisms, and all the other stakeholders, join us, and we're having these candid conversations on these trends and these new aspects around arbitration and ADR. And today is no exception. So mine is to welcome you, to lend us your minds, let us have this discussion, and we'll be led by the moderator, who's part of our members of the Young Members Steering Committee, Mr. Daniel Zeki, through this conversation. We will be cutting base later on after the discussions, and we'll be explaining to do what other things we have in store for you. But at this very moment, allow me to welcome you and hand over the mantle to Dan so that he can take over the program and the rest of the discussion. Daniel, karibu.
Thank you, Madam CEO. Just confirm that you can hear me.
Dan, you're muted.
Madam CEO, can you hear me now?
Dan, we can hear you.
Dan, you're still muted.
We
can hear you.
Thank you.
Dan, we can hear you.
Thank you.
Confirm we can hear you, Dan.
Thank you, everyone. Good afternoon, everyone. Thank you so much for coming. I see on the platform we have our good friends from outside our borders. We say karibu sana, which is an endearing Swahili word for welcome. It is a pleasure to have all of you for what we hope and promise to be a timely and engaging discussion on some of the proposed changes to Kenya's arbitration framework, and more importantly, what those changes mean for the future of arbitration in Kenya. This timely discussion comes as Kenya's proposed Arbitration Amendment Bill 2025 signals a significant reset for Nairobi's arbitral ambitions. The reforms, and this is according to the proponents of the bill, aim to streamline procedures and reinforce finality in arbitration proceedings, which are key factors that will shape Nairobi's competitiveness as a preferred arbitration hub within the continent and beyond. As your moderator for the next 2 hours or so, my role is essentially to ask the difficult questions, keep us moving, and hopefully get our panelists to disagree with each other just enough to make the discussion interesting. And as has been introduced this afternoon, we are privileged to have 4 panelists who are no strangers to us. And in the interest of time, I will not read out their bios again, but allow me to once again just introduce them in no particular order. We have Honorable Retired Lady Justice Mary Angawa. We also have Miss Jackie Oyoyo Githinji, Dr. Henry Murigi, and Mr. Samuel Mwaniki. Thank you all for being here. So with that, we get started. I am going to give the panelists 2 minutes each to give us their general overview of the bill. And in doing so, they're going to give us their views in terms of both the good, the bad, and the ugly. And then we can go to the technical discussion. And I am going to start with the former chair, Madam Jackie Oyoyo. Welcome.
Thank you, Dan, and thank you, Evelyn, for the introduction. First of all, let me just dispel some of the ways in which I have been introduced this afternoon. I'd like the participants to just acknowledge me as an arbitrator, because that is the capacity in which I am speaking this afternoon. If indeed I was speaking on behalf of the center, then I think I would be usurping the role of the current chair, who properly took that seat in October of last year. So with that clarification, let me just say my overall view of the amendment bill is that it overshoots in some instances and it attempts to rationalize in some instances. And to that extent, then it is an effort to try to bring to life some of the edicts, if you will, of the NCIA Act, as well as the proposed national policy on ADR, which I hope a good number of you have at least become familiar with. It will be necessary for you to have that background information in order to appreciate some of the amendments that we're going to discuss this afternoon. So Daniel, I don't want to take up too much time. I will pause there and we can engage further as we proceed. Thank you.
Thank you, Jackie. I think that's a very good start. I'm going to go straight away to retired Lady Justice Mary Ang'ao.
Thank you very much. I'm privileged to be here participating in this panel. My concept about it is that this arbitration amendment bill of 2025 is actually to clarify the role of Kenyan courts in arbitral proceedings. And it's important to note that one of the things that has really been disturbing arbitral proceedings has been not really the interference of the court, but allowing the courts to come in and out of arbitral proceedings. And as a result, we have this concept about delays. We've got this concept about the whole concept is not going through very smoothly. I'd like to see this new bill as one that will be in line with the requirements of the UNICITRAL Act model law, so that we should be able to have a more efficient way in which we have the arbitral proceedings going before arbitrators. Thank you.
Thank you, Judge. That forms the basis that we shall be discussing later on some of the technical issues, especially the role of the courts. We appreciate you. And next, I am going to have Mr. Mwaniki Samuel. Thank you.
Thank you very much, Daniel. For me, I think the intention of Nairobi to be the point of call for international arbitration has been an ambition since 1995, when we amended the current act. And then in 2013, we established NCIA. And I think that's when the arbitral court was created. And I think this bill is now hopefully a culmination of making Nairobi attractive to the international arbitration user. You notice that the bill has aspects of speed, specialization, certainty, and modernization. But again, the bill has instances where one may consider that it may have gone a little too far in terms of trying to position Nairobi as an international arbitration center. As to whether the bill will eventually bring that desired attractiveness may very well turn fast on whether the bill will be passed into law. I think that is cannot be assumed, but also on how it will be implemented. For the user, I think the proposals in the bill will only become relevant if those proposals make international arbitration or even domestic arbitration are more aligned to the international, more aligned to the matters of arbitration as the user may desire of them. I won't say much more for now. I think the discussion later on, we will be able to look into that. Thank you.
Thank you, Samuel. Thank you for those insightful introductory remarks. Lastly, let me call our CEO and Registrar of the NCIA, Dr. Henry Muridi.
Good afternoon. Confirm you can hear me, Daniel?
Yes, Doctor, we can hear you.
Very good. So first of all, thank you so much to the Chartered Institute of Arbitrators for setting up this conversation. Also for inviting me to take part in this discussion. I really am grateful for the honor of the invitation. Secondly, is to say that this conversation has not started now about the amendment to the Arbitration Act, and I don't think it will end with this conversation. So it's an ongoing discourse we must continue to engage in. The third thing to say is that there's a book written by Isaiah Berlin called The Fox and the Hedgehog. And Isaiah Berlin tries to draw a parallel with the mentality of a fox and the mentality of a hedgehog. The fox is able to go very far with its ambition of pursuing whatever it is it's pursuing. And the hedgehog is able to go out and immediately do a patch or do whatever it wants and then go back in. A legislative drafter must aspire to have those kind of two mentalities. And Isaiah Berlin tries to say that in any attempt to develop anything for the future, you must maintain a long pause and reflect on what you want to do in the future, but also be careful enough not to miss the small details. It is in that context that I look at the amendment, the Arbitration Amendment Act, that it has very good ambitions for what Nairobi needs to look like, but also it has very small details that are sought to be clarified, that have remained to be ambiguous. Thirdly, or rather lastly, is to say that to be able to fully understand the Arbitration Amendment Act, I think you need to understand the history and the journey we have traveled to come to this point where we have a proposed amendment bill. And to do that, you need to have several other documents to help in a fuller picture, which is the National ADR Policy, the Dispute Resolution Bill, and also the Construction Adjudication Bill. Those are helpful additional documents that can give the fuller picture of what the discussions will be today. With those few remarks, I think I would like to yield the floor. Thank you so much.
Thank you, Dr. Henry. I hope by the end of this discussion, we are able to perhaps get a headway as to whether we are a fox or we are an hedgehog. Now, I am going to start with you, Honorable Lady Justice Mary Angawa, on the point that you left as to the bill clarifying the role of Kenyan courts in arbitration. And my question this time around revolves around judicial intervention and judicial intervention and finality perspectives, whereby we want to talk about the jurisdictional issues that the bill brings with it. When you look at the jurisdiction that was initially conferred by the High Court, you know, most of it has been moved from now the High Court to the Arbitral Court, sections 12, sections 14, 15, 16, 17, 32, and many others. However, the most contentious and litigated upon section, and specifically section 35, on setting aside arbitral awards, has not only been retained at the High Court, but now we see there's, in fact, and it has gained a new layer of appeal to the Court of Appeal. In your view, what is the reasoning or the wisdom behind that split in jurisdiction? And could that in itself inadvertently generate more satellite litigation?
Thank you. I think you are right in bringing that very important point. Why is it, you know, first of all, we must understand that the modernization of the bill is to actually bring all the jurisdiction under the arbitral tribunal that is there. But here, you are quite right. We're having a situation where Section 35, the only one that has come up that would actually give the right of a person to go to the Court of Appeal to appeal. But those sections, if you can just actually look at, it is basically one that says that the leave of the Court of the Appeal is required for any appeal for it to be granted or refusal to set aside and to go to the High Court to go to the Court of Appeal, where I think it's a situation where we are trying to marry the Nutu case, where we are talking about what is known as exceptional circumstances. There are rules where the appeal is not allowed automatically to the High Court or to the Court of Appeal, but there are circumstances that this is a leeway that has been given and is actually marrying the Nutu case that has been quite debated for quite a while. I think also that the issue of bringing the courts, restricting the courts and bringing it all under the tribunal is very important. But this Section 35 is a challenge. It is that somebody can challenge the award, some legal technicalities that needs to be done.
Thank you, Judge. And just this jurisdiction that was initially before the High Court to a statutory body, in this instance, the Arbitral Court, established under the NCIA Act, which we would ordinarily say is outside the ordinary court hierarchy, and then making its decisions final and unappealable. Is it consistent with the High Court's unlimited original jurisdiction under Article 165(3) of the Constitution?
Yes, it would appear that it is inconsistent, but the aim is to bring this act in line with the UNICITRAL rules and laws that are there. I personally do not think that it is a contradiction, that there should be a leeway given to the person who wishes to challenge, although the jurisdiction and the objections that are there are meant to be restricted. The Constitution is supreme, and if anything contradicts the Constitution, yes, that will bring litigation and saying that the finality should have been there. And the tribunal, which is there, should not be seen to be contrary to the Constitution, but the aims and objectives of that particular tribunal is important, and it should be upheld. That there will be minimum interference from the courts and other bodies to the arbitral situation. Thank you.
Thank you, Judge. I think we are going to elicit more, but allow me at this point to interrogate that and test whether the mechanisms that have been put under the amendment bill actually help or hurt the speed with which we envision arbitration to be. Former Chair, Jackie, you talked about the bill, overshooting in some instances and rationalizing in some others. When you look at Clause 8 of the bill, it proposes to repeal the entire of Section 14 of the Principal Act on, which provides for the challenge to procedure of an arbitrator. Specifically, the proposed section 1411, we see now it stays the arbitral proceedings while a challenge to an arbitrator is pending before the arbitral court. My question is, why replace a system where arbitration can continue at the party's risk, why with one that forces a mandatory stay every time someone challenges an arbitrator?
All right, so let me pick it up from where the judge left off, because I think it would be a little bit dishonest of us not to recognize that there is a new competent authority, if you will, being suggested. And the idea behind that competent authority is to bring some level of expertise, as has been said in the introductions, and also some level of expediency. So well, firstly, do I think it is a good idea to stay the proceedings pending the decision? My short answer is no, and that is purely from a practitioner's perspective. Because as Section 3A of this very act has said, or this bill rather has said, the idea behind an arbitral process is expediency, its efficiency, and finality. So to the extent that then we're introducing some sort of fetter to the jurisdiction of the tribunal to proceed, it does raise some questions for me as a practitioner. Nevertheless, cognizant of the fact that the arbitral court has been, there are timelines that have been proposed for the timeline within which the arbitral court should render its decision, then that should give some level of comfort, perhaps not the purest level of comfort that we would imagine, but it does give some level of comfort in terms of there is a definitive timeline by which that decision should be made. And indeed, if that decision is not made, I think at that point, if the time has lapsed, then the tribunal should then be able to continue without then the cloud, if you will, of the stay being over the head of the tribunal then.
Thank you, Jackie, for that. I think my immediate follow-up question would be, in light of what you've just said, are we overshooting in terms of some of those, what is the reality of some of the provisions where we've seen the bill proposed very strict timelines within which the arbitral court or the High Court in this instance should make a decision on some of them? For example, we've seen 14 days, we've seen 30 days, we've seen 90 days. What is the practicality of that? And in asking this question, I borrow a leaf from what we've seen happen with the Small Claims Court Act, which provided, a 60-day rule for making decisions, but we've seen the ripple effect that has come since then. So are we overshooting? Are we overambitious with that?
I think it would be unfair to impose some of these timelines on the High Court simply because we don't have what we have, in certain jurisdictions where there are dedicated desks or dedicated practice areas within the courts, specifically to deal with matters ADR. And I think the arbitral court is, if you will, quote unquote. My own personal concerns about the arbitral court are whether the market, and this is you, me, and everybody in this proceedings this afternoon, are ready to embrace the arbitral court as an established court by statute. And let me dial it back a little bit in the context of Section 35, for example. Kenya does not operate in a vacuum when we talk about arbitration. And Section 35 is almost word for word a mirror of the New York Convention, specifically Article 5, on the setting aside of arbitral awards. Now, what Kenya has gone and done in this bill is to then attempt the next level, if you will, of beyond the, let me say, the well-established international grounds for setting aside. We have then gone on to open our own door in terms of which court is hearing what grounds. And I had, the discussion between you and the Honorable Lady about whether we're codifying new to. So Section 35, as a mirror of the New York Convention, as it currently sits in the Arbitration Act, is sufficient to give some sort of credence to the doctrine of finality under arbitral laws. My concern, if Kenya is to be a suitable seat, is whether we're opening doors that will then prolong processes, that will then make us more protracted in terms of how we operate. So I think there's that balance, and you see this tension throughout this bill around what to attempt to codify, including the role of the court's intervention. And these are already limited, but I think there's a further attempt once we open the door to enter the High Court, when that door should be closed and on what grounds that door should be closed. So my personal concern around the arbitral court, and I said this a few minutes ago, is whether we're ready to accept it. And the short answer to that question is the NCIA Act is an act of parliament. So to that extent, then, the drafters of that act had envisioned a situation where we can have this specialist court that is determining, that has a specific mandate to determine specific questions. And that's why in my opening I said, if you haven't read the NCIA Act, then this conversation might go a little bit over your head in terms of some of the amendments. Be that as it may, going back to the New York Convention on Recognition and Enforcement, what that convention talks about, and it doesn't even talk about a court, it talks about recourse to a competent authority. So in our minds, in the Kenyan market, we have to now start to embrace or consider embracing the NCIA Arbitral Court as a competent authority on matters, arbitration, dispute resolution. So to that extent, Section 1411, which you have mentioned, and some of the other sections of the Act, and I'm sure we'll continue to talk about this as we proceed, are entrenching the role of that arbitral court. If the court is given the necessary resources, then the court, and I'm sure you all saw that in the last 2 months or so, the court has finally been constituted, then the court will have its work cut out in terms of, assuming this bill is passed into law, meeting all these deadlines. I think we would be unfair to the High Court if we attempted to impose these same timelines on the High Court as it currently sits, Dan.
Thank you, Jackie. There are two questions that arise from that, but we'll circle to them in a few. And just to build up on that, and this question is to the CEO of NCIA. Jackie talks about the unreasonableness of these provisions, the strict timelines to the High Court. Now, applying them to the arbitral court specifically, do you think they are reasonable? And is the NCIA prepared? If this bill were to be passed today, is the NCIA prepared, to actually fulfill the strict timelines that are being provided for, or what can actually be done to build the capacity of NCIA and the arbitral court? In 2 minutes.
Okay. Thank you, Daniel, for that question. So, is the NCIA prepared? I think the answer is yes. We already now, as Jackie alluded to, have the arbitral court in place, and the arbitral court is basically envisioned to assist in creating more credibility and quality assurance to the processes that are being undertaken under the NCIA as it is. And the context is because NCIA offers both domestic and international arbitrations, and therefore there is a need to provide that assurances, including at the point of appointment, and anything really done by the guise of the NCIA Act. So in that framework where we are operating under the NCIA Act, the arbitral court is in place and ready to deal with any matter that is referred to it, both under the NCIA Act or the Section 21 talks about any written law. So basically, should the Act become law, then the court will be, the arbitral court will be required to then take up any matter that is presented for it. So the answer is yes, it is prepared. Now, there are operational issues that are tied to that then come into question. We have, for instance, rules that govern how the court works. And I think that's a conversation that then we could have separately. But what I could tell you is that with the constitution of the arbitral court, their first work is to make sure that the rules for the court are set up, and of course, with the guidance of the NCIA board, which oversights what the court does. My view would be that if you look at the practice worldwide and what arbitral courts do worldwide, some do different roles, but the general consensus is that there is need for an additional layer of comfort for parties to know that, obvious things don't miss, and then you're required to then wait for a court to make a determination one way or the other that could be corrected, sort of give an assurance to the process. So it is in that lens that I look at the role of the court vis-a-vis the intended amendment, to then say that yes, I think the arbitral court would be ready and prepared to take on the tasks that are being asked of them at the bill. Thank you.
Let us remain on that positioning for a minute. The proposed amendment, specifically Section 6.4, the Principal Act, channels the appointment now of the default arbitrator to the center after a stay of court proceedings. But this is only if the parties have not named another appointing authority. So when we're talking about all this positioning on the part of the NCIA, how much of Nairobi's institutional ambition depends on parties simply opting out of that default? Differently put, what is NCIA doing that would give parties confidence to choose it over other established arbitral institutions, whether in Kenya and within the continent?
Yeah, Daniel, that's quite a loaded question. It has, I think, three parts. The first part is in line with, of course, the idea of this being Section 6.4, creating a default mechanism. So what you have to go back to is, why is it being referred to as a default mechanism? And the obvious answer is because of the principle of party autonomy. Parties have the first go at it. They have to then sit and determine that we want to avoid a situation where we are going to NCI. So it's a default mechanism in that way. But again, so that there is no delay or lacuna or gap, if parties leave that out, then that becomes a safeguard to ensure that the court is not wondering what we do with this question of appointment of an arbitrator that was left ambiguous by the party. The second part to your question is, what is Nairobi's, or rather NCIA's ambition? And I think for NCIA, the ambition is to become an institution that offers quality arbitration and domestic and international arbitration services that are assured to the extent of the rules that are provided for under the NCIA Act, and also global standards that are available. So we have an ambition of being a center that excels in providing excellent dispute resolution services, especially in arbitration and mediation. If you look at Section 5 of the Act, it even provides, I think, about 17 more roles or functions of the NCIA. So the work is already cut out for the NCIA. Now, the last part of your question is how much of this default position is what NCIA is relying on. I'll tell you this. First, the idea of the amendment is not to necessarily create work for NCIA. NCIA has its own operational framework, a strategic plan, legal and legislative framework that governs its work, and even helps in projecting what kind of cases do we want to attract. So NCIA will not be said to be relying on a default position to then generate work. It already is going in that direction of offering institutional arbitration. And I may interest you to just look at some of the statistics of what kind of work that we are doing at the NCIA, and what you will find is that there is an increasing preference for NCIA, looking at just the last 3 years by parties who want to choose NCIA. In 2024, 2023, 24, we had an increase in our cases with about 115%. In the last financial year, 25-26, it's gone to about 130%, meaning the cases are growing, parties are preferring the center, and parties are choosing NCIA. So NCIA has its journey that it is struggling without necessarily having to rely on this specific provision. I would interest you to look at our caseload reports and over the years and see what you see as a trajectory of growth for NCI.
Thank you, CEO, for that. I would want, before we go to look at this bill from the commercial user perspective that Mr. Maniki will come to talk about shortly, I would want us to just circle just a bit to Section 35 once again, because this is a very contentious section within the arbitration circles. Judge, the proposed Section 35, specifically clauses 5 to 13, we've seen they create the express leave to appeal mechanism to the Court of Appeal, and they provide for all those grounds there. Does that express detailed appellate mechanism contradict the bill's own finality objective set out under Section 3A and 19A, as Senior Jackie has talked about, against the one-tier final no appeal model that has been provided for elsewhere, and specifically under Section 14 and 17 of the Act, of the bill?
The bill. Yes, thank you very much for that specific questions. It is the items that have been identified to be probably controversial, or items that should be able to make one think. For instance, challenging the award. We had said earlier on, I think even Jackie mentioned it, is to try and bring it in line with the unilateral model law, Section 34. And also the objectives and the jurisdiction, yes. You have the situation where it is actually questionable why it is that we are going directly and bypassing the finality of the High Court. But in order to bring the jurisdiction and the finality of the matter in an expeditious way, then it probably is necessary to have those two layers kind of jurisdiction where you need to appeal against those particular sections.
Thank you, Judge. Jackie, allow me to come back to you once again, specifically still on this question of Section 35. And we want to test the internal consistency of the finality objective again, as of the arbitral awards under the bill. We have seen a very interesting development from the Court of Appeal, which has since become a debate in the legal circles in the last few months. On 26th of June, 2026, the Court of Appeal in the case of GDC versus Lantec held that the Supreme Court lacks jurisdiction over Section 35 appeals. And we know that has been the position all throughout, even from Newt. However, 2 weeks later, on the 10th of July, 2026, once again, the Court of Appeal, this time differently constituted in the case of Centurion Engineers and Builders Limited versus Kenya Bureau of Standards, certified a Section 35 appeal as one raising matters of general public importance, which then paved way to go to the Supreme Court. Against this backdrop, does the proposed Section 35(14), which ideally seeks to foreclose any further appeal from the Court of Appeal, effectively or essentially oust the Supreme Court's jurisdiction under Section 163(4)(b) of the Constitution on certification of matters of general importance, or can the two provisions be reconciled?
I think I would prefer to take the latter position, that the positions can be reconciled, for the simple reason that a lot of times that these debates arise is when there is indeed a serious issue to be determined. As a student of law, I cannot fathom a situation where the jurisdiction of the Supreme Court can be ousted, particularly by a court of lower jurisdiction. Even just a simple reading of the Judicature Act would negate that very thinking. So for me, I think, and it's unfortunate that in certain jurisdictions such as ours, when we have problems, we then legislate for problems as opposed to looking for what the ideal situation would be. So what you have illustrated as you started to ask this question around the tensions or the I don't want to use the inconsistencies, but the different determinations that are coming out of the Court of Appeal in terms of the jurisdiction of the Supreme Court, then point to the fact that there needs to be some finality in terms of determining when the Supreme Court can indeed enter the chat room, if you will, on matters arbitration. And I think that was one of the criticisms of you two around not saying with finality or definitively when the Supreme Court or when the Court of Appeal can have jurisdiction. So Section 35(6), as it is now proposed, opens a new chapter, if you will, that might be the subject of even more litigation, which is this whole question of some other special reason. It is as good as public policy under Section 35(b)(2) in the current Act, 2(b)(2), where, and you've heard it before, public policy is an unruly horse. Those are not my words. Are we also then creating another unruly horse in the form of some other special reason? So can we just limit it to the questions of law of general importance? Or should we also then be introducing this new concept of some other special reason? Because what is it that would be so special as to be outside a question of law of general importance or outside of some misbehavior, if you will, on the part of either a preceding court, such as the Court of Appeal, the High Court, or indeed the tribunal as it was then constituted? As we go along this hierarchy of when certain doors are opened and others are closed, the overriding question is always whether there has been due process and whether there has been some gross irregularity. Those are the questions I think that typically find their ways to the court. So this is why I said in some instances the Act is overshooting and in some instances it's trying to redress. So for me, it would have been enough for the drafter to stop at the proposed new 35(6)(b) without then introducing that new subsection C.
Thank you, Jackie. I think the conversation keeps getting interesting over and over again. And just to build and prop further on that undefined limiting standard that perhaps you're talking about, I have a question for Mr. Mwaniki, Samuel. Samuel, when you look at clause 12 of the bill, it proposes to repeal section 19A of the Act, which provides for the general duties of parties to arbitration. And the bill proposes, or rather provides a rider that in agreeing on how these parties are to resolve their disputes, then the same is subject to what the bill now has coined as safeguards necessary. Is that rider provision meant to achieve? And could it become a vehicle for broader override or interference of party autonomy than is actually intended under the Act? Thank you.
Thank you, Daniel. I think the debate is revolving also on the aspect of, on one hand, there is the intention of giving parties autonomy. On the other hand, there is the need for finality. And then on the other hand is on appreciating the reality that has been brought by recent litigation. So yes, I agree, this provision appears to give on one hand and to take on the other. There doesn't appear to have been a scenario where then the discourse has had its equilibrium. And you can see throughout the provisions that have been proposed that there is no meeting of minds as to where one needs to stop. There are instances where the Act appears to propose a remedy, but at the same time, it now opens another room for probably further litigation, further engagement, without then closing the door. And where it is supposed to open a door, then it appears to close. So yes, I agree there is that concern that the bill has brought generally. And I think that's one of the issues that needs to be reconsidered. Thank you.
Thank you for that, Mr. Mwaniki. Another question that we've seen is also bringing in issues is the proposed amendment to Section 9 of the Arbitration Act on a notice of arbitration. Does the loss of the fixed day of receipt rule that is provided, under the new Section 9, change how you would actually draft a notice clause today?
Yes, definitely. But then if you look at the proposed amendment, it also introduces some concern because while it appears to embrace technology, then it introduces an issue about delivery. Then one would wonder, when is an email considered to be delivered? Is it when it leaves the sender? Is it when it gets to the receiver? What happens when there is when it goes to spam, for example, or when there is an automatic bounce back? So yes, that proposal in Section 9 creates some concern to a practitioner in terms of when a notice is deemed to be delivered. So then that will translate to the drafters. As far as the drafters are concerned, they need to be clear during the drafting as to when that notice is considered to be delivered, because the Act as proposed does not seem to clarify that aspect. So if I was sitting as a drafter, I would probably be a little more intentional in identifying exactly when that notice is deemed to have been delivered. So thank you.
Thank you, Mr. Mwaniki, for that. And I would just want to remind our panelists, our participants, to utilize the chat function and raise any questions that they have, because we will get to our plenary, whereby we will be getting questions from the panelists. So please, from the participants, sorry. So please keep sending out your questions, and for the panelists, they will address them at some point. Mr. Mwaniki, I am not yet done with you. I would want us to shift gears a bit and talk about the one thing that we have seen being discussed over and over and over again in conferences, in webinars. And now we see it has been provided for under Section 39, the proposed Section 39 of the bill. When you look at the proposed Section 39, specifically A1A, it appears to disqualify funding arrangements structured on non-recourse success fee basis, which is how most commercial funding actually works when it comes to the world of third-party funding. In your view, does the bill offer a regulatory framework for third-party funding as is currently model? It actually
for the first time, I think the bill recognizes the importance of third-party funding. I don't think that is a new thing. And the appreciation of that party funding as the conventional way of doing things, especially for large commercial disputes. Outcome contingent.
Lastly, on that part, Monique, if you were part of the team drafting this bill, what would you do about that specific section? What solution would you offer?
Yeah, that's what I'm saying. First and foremost, that section, that 9(1)A, needs to be redrafted, in my view, to align with the international market and also to align with the other provision in the section. If you read through the section, generally, you'll find there are references to return. You cannot, on one hand, talk about prohibiting a return, and then on the other, you're saying that you are considering return. So that needs to be realigned. So if I were to draft, I would definitely look at that section, that 9(1)A, and rephrase it so that it allows the conventional scenario as we owe it in the international market, where that party funding will depend on contingency, and that is the only way, in my view, would be able to attract funders, and will make even Nairobi more attractive. That is my view. That particular section definitely needs to be looked at. Thank you.
Thank you. I am going to invite Jackie back just to help us understand something again about the wisdom behind the drafting of the proposed section 39. Why does the bill only restrict third-party funding to international arbitration? What happens then to domestic arbitration where there is potential for third-party funding?
I suppose in the domestic situation, I can't answer your question directly because I don't know what was in the mind of the drafter. But I suppose that it doesn't, by not specifically mentioning domestic arbitration, it doesn't preclude third-party funding in the context of domestic arbitration, but for the fact that in the way it is drafted, then it borders on questions of champati, which, as we all know, domestically is frowned upon. In fact, is not encouraged. So to that extent, maybe that's why the drafter was careful to not specifically talk about the domestic arbitration scenario. I think overall, this section 39A would simply have, and I agree with my fellow panelists, this section could simply have noted and appreciated that third-party funding exists and left the detail of how third-party funding is to be managed, if you will, to any rules, if you will, that the parties may subscribe to, because a lot of institutions are now drafting their own rules around third-party funding, or indeed left it to party autonomy. I think most rules have gone the way of simply requiring certain disclosures, including the fact of the third-party funding agreement and possibly the identity of the third-party funder, without necessarily then going into the level of detail that the statute has gone into, or the process that needs to be litigated or legislated in the manner that the bill has proposed. Daniel.
Thank you, Jackie. Judge, if for one reason or another, the third-party funding regime as drafted and as the panelists argue discourages conventional funding structures, then what does that do to Nairobi's pitch against seats that actively court funders in arbitration?
It will definitely affect Nairobi. You see, what we need to understand is that the center must be in line with all the other centers. If all the other centers are doing it and then we are not doing it, you'll find people will try and avoid using us. So we need to have ourselves aligned in order that we might be attractive and that we might be able to actually deliver. Yes, it could be a cause that people might say it's a question that people may not be happy about it, but it isn't the issue of people not being happy about it. It's the issue of, is it being done elsewhere, and is it going to be a universal type of concept?
Thank you, Judge. And lastly, on this part, to the CEO, we've seen jurisdictions such as Singapore and Hong Kong regulate third-party funding through disclosure and funder capital adequacy requirements, rather than restricting the funding structure itself, as our bill seems to be doing. So in your view, does Section 39 generally on third-party funding put Nairobi at a disadvantage against such seats? And the fact that we want to position Nairobi as the next global, continental and global arbitral hub, what do we need to do?
Thank you, Daniel, for that question. And I just want to follow up with the conversation from where my co-panelists left it. I'll begin by saying that it is a practice world over that third-party funding is being, allowed and permitted in arbitration. So to the extent that the bill adopts that, I think that's a welcome suggestion. Secondly, is to say that some of the feedback that we received when we were collecting views sometime last year is exactly some of the things that were addressed in the review process, including the concern you raised about international arbitration. And the bills, as I know, have been forwarded to the Attorney General, have sort of opened that window for any arbitration, not just international arbitration. We don't know how far that will go, but at least that is welcome feedback. Now, the other thing I want to say before I answer your question is Section 39 1A, as it is an attempt to balance the long history we have with maintenance and champati, the discourse to try and limit those, as you would imagine back then, the bourgeoisie taking advantage of processes that are ongoing before a court or a tribunal with a view to taking advantage of that. So there was a tension there that the drafters had in mind with a view to limiting that. However, because the journey of the bill is still in its early days, I would say, or we are still progressing, these are some of the conversations that I think we should maintain in terms of clarity. The last thing I want to say before I come to your question, sorry, I'm holding the space, but is this a legislative drafter, not one, but from reading, you would imagine has to worry with the tension of being very broad and very specific on the one hand, and on the other hand, being limited and restrictive. And there is a reason for that, because then you want the practice to dictate and determine what that will look like. I think as a Kenyan community and a legal community, we want the latter, where we want to go into so many details. And in going into so many details, we then leave out the room for practice. So that's how I would look at the Section 39, because of, in terms of the level of detail to which that question of third party has been addressed. Lastly, to your question, Hong Kong, Singapore, if you look at their approach, for instance, I'll begin with Singapore. Singapore, this is part of their civil law, or rather civil law third-party funding regulations. So it's not just addressing third-party funding in arbitration. It's basically addressing much more wider area of practice than just mainly arbitration. So, and that is the framework within which Singapore would then approaches this question of third-party funding. Of course, they progressed that in 2027 with additional legislative amendments to the what they call the conditional fee agreement in the legal practice, so that they enforce it and make it much more tighter to allow and address the concern of maintenance and champerty, so that then it's very clear. Hong Kong, on the other hand, they basically just rely on the code of practice for third parties, and then, as Jackie mentioned, develop their own, or in the process of developing their own third-party funding rules. And I think that's a practice worldwide. For us as a country, I think this is a welcome step. Of course, obviously, we must improve it to make sure that it is in line with best practice. And I think this is the whole essence of this engagement, so that then when the legislative process is ongoing, then some of these matters are picked out and thrashed out and ironed out, so that then it's clear. Thank you.
Thank you, CEO, for that. I would want us to shift our gears just a bit and talk about the new clause 14, which is now the proposed section 28A to 28C, whereby they are introducing the fast track procedure with a 6-month default award timeline and fee reduction sanction of up to 5% per month on the arbitrator, whereby the tribunal causes delay. But we see that it is silent on sanctions for party cost delay. When you look at comparable fast-track regimes such as India, they apply timelines to arbitrators, and also counsel, but ours does too, but it is one-sided. So my question becomes, what happens? Is the proposed bill too harsh on the arbitrators and too lenient on the parties, especially where there is delay that is caused by the parties, which we've seen happen? And that question, I would start with Mr. Samuel.
Yes, I would say the mischief probably is understood, but there is a subtle, there is a concern that may be derived from that action, because then what comes to mind is that some arbitrators may frown upon taking up some matters, especially complex matters that may not be concluded within the timelines that are proposed by the bill. So building capacity may now become a challenge. Then also, of course, the mischief is understood where some arbitrators may have been viewed to stay with awards rather long. But again, we must balance that against the need to build capacity. So yes, I hear you. Again, the parties themselves probably may have caused the delay, but I think I'll look at it from the fact that there's being a party-driven process. Then the parties probably may have their inbuilt mechanisms on how they can fasten the process. And the arbitrator, as a master of process, should be able, in most instances, to manage the process in such a way that then there is no undue delay on the part of the parties. So my concern really is about what effect will this amendment have in terms of, attracting qualified arbitrators. Thank you.
Thank you, Samuel. There's something else specifically about the introduction of what we are calling an emergency arbitrator. And I think this is the part that we should have begun with, but it's okay. When you look at clause 2, it now talks about an arbitral tribunal now, being expressly defined to include an emergency arbitrator, but only one appointed pursuant to the rules of arbitration agreed to or adopted by the parties. Now, my question is, does that definition as it currently stands do away with, or rather not provide for ad hoc arbitrations without such rules? Because we see they're not getting such an equivalence. So is that gap intentional, or what was the intention behind that specific definition? And this question is specifically for the judge.
Thank you very much for that particular question. If I could just take a step back and just go back to the other question that was attempted to be answered or was answered by my other panelist, where there was no pressure on the parties or the lawyers. There's a lot of pressure on the arbitrator to finalize a matter, but not on the party who is representing the parties. I would say that I think the Act actually outlines where orders that are given by the arbitrator are not complied with or are not done. If it says, please do a certain thing within a certain time and it's not done, then there would be a situation where the arbitrator has got control to make sure that what is required to be done, to be so done, but to do it gently and not to use force, so to speak, but to be able to bring it to pass. So I think the rules actually provide for it, and I don't think that there's any unfairness that it's only on the part of the arbitrators. The arbitrator. It is important that timelines are put in place, but there should be a clause that says, it can be easily give a little bit of leeway here and there. Now, may I just get your second questions that you wanted to put to me on the issue raised?
Thank you for that input, Judge. My question was on the definition of an arbitral tribunal to include an emergency arbitrator. But then the scope that is provided for and the proposed section 2 is an emergency arbitrator only appointed pursuant to the rules of arbitration that have been agreed upon or that have been adopted by the parties. It seems that it does not provide for ad hoc arbitration without such rules. So the question was, is that intentional, or what is the reasoning or the wisdom behind that?
You see, arbitral proceedings is party-driven and is of the consent of the parties. By having that clause in, you will cover the issue of consent. You'll cover the issue of parties agreeing. But when you have an ad hoc, the parties might turn around and say no, although we would have wanted an ad hoc situation, but it was not provided for. So to my mind, it shortens the aspect of somebody now applying, making the whole process a bit longer. It's the whole issue about this bill is how quickly can we have the process and the procedure done? And so I find that having an emergency arbitrator is one that should actually be done and agreed to before. And so when the issue arises, it just goes straight in because it's already provided for.
I think, thank you, Judge. I think I would also wish to get the comments of Jackie on that. So Jackie, welcome.
First of all, Dan, I think the draftsman has a somewhat disconnected definition of emergency arbitration, which in this act is encoded in part, in this bill, is encoded in part 4A as fast track arbitration, and what they intended possibly as fast tracking arbitration. Those are two very different things. And I think none of those things has a place in statute. I think currently sections 19A and 20 deal sufficiently with the question of expediency and squarely with the question of the arbitrator being the master of procedure. What can then happen if the parties want an emergency process? For example, the subject matter is of such nature as to require a quick decision, then they can adopt any such rules as they want or any such processes as they want. It doesn't have to sit in statute. In fact, for me, the first thing, if I was a party representative, as opposed to an arbitrator, I would first and foremost tell the parties to refuse to apply Section 28A because it's an optional provision. The provisions of this part shall apply to domestic arbitration unless the parties have otherwise agreed. So the first thing the parties should agree is not to have this particular section applicable unless they intend for an emergency process. And if they intend for an emergency process, then what they should do is adopt well-established institutional rules of whichever ones they apply. The NCI has their rules, the LCIA, any institution of repute has emergency arbitration rules, which the parties can adopt into their process. What this section is attempting to do is to hasten the process of arbitration, which is fine. However, in so doing, it then introduces pages and pages of requirements in a specific number of days, then go to the arbitral court. The arbitral court can then remove the arbitrator and replace them. Why? You're taking the parties back to day one, as opposed to a fast-tracked process. So I think the intention may have been emergency arbitration, but the fact of the way it is drafted is such as to then force the parties, and I'll use that word, because the word used is shall not may, force the parties in a domestic arbitration into a fast-track process that they may not be prepared for. So if they're not prepared, they themselves are not prepared for a fast-track process, if they don't pay attention to Section 28A, they are already going to fall foul of the timelines. However, the only party in these, and I'm using the term party loosely, the only party in these proceedings who is going to suffer the consequences of delay is the tribunal, and no tribunal worth their salt is going to take on that responsibility. So me personally, the first question I will be asking parties when we have that preliminary meeting is, are you adopting Section 28A and Part 4A into these proceedings? Are you prepared? If you're not prepared, then I suggest that it will not apply to these proceedings. Otherwise, as it is drafted, I don't see the mischief it is attempting to address. And if it is attempting to introduce emergency arbitration, I think the proper way to do that is to still leave the act as it is, as far as arbitration is concerned, with sections 19A and 20 adequately taking care of the question process. Thank you.
Thank you, Jackie. And I think the good thing is this discussion is eliciting a lot of debate and different opinions on that. But in the interest of time, I am moving towards conclusion so that we go to the plenary. But we see the current act, and this question is for Daktari. The principal act at Section 7 provides for interim court orders, in support of arbitration and there's no statutory expiry of those interim orders. However, we see that Clause 5 intends to amend Section 7, rather introduces Section 7.3, and whereby now we see that they are introducing a 60-day automatic lapse of those orders. Whereas this, to some people, may be deemed as a welcome check on indefinite interim reliefs, the question is, does this extension of the extension route of open-ended, interim orders have any problem, especially what standards then do you have to apply when you are seeking for such an extension? Who bears the burden of proving and what standards they actually need to prove when they want that extension to be granted? Daktari, in 1 minute.
Well, you have taken two to ask the question and you want me to answer in one. Let me try my best. I think the idea of the bill is to basically provide certainty in terms of the interim reliefs, interim orders that are granted. That's the organizing principle behind the requirement for a certain timeline, because we have seen injunctions or orders that have been granted that are almost in limine without certainty as to that. So to the extent that there is an attempt to provide a cut date or a cut situation, then I think this should be something very welcome. That's all I can say. And then the other thing I wanted to say, now that I have the floor, the process of receiving the views and the comments from the public, including Chartered Institute of Arbitrators, really helped in refining some of the challenges that are being discussed now. And I think because of the position that I see, I have the benefit of viewing some of those changes that have been done, of course, with the guidance from the NCIA board that, for example, the question of emergency arbitration, I think that has been, because I'm looking at the bill as forwarded to the Attorney General, doesn't have some of those contentious provisions on emergency arbitration, because as it is, Section 19A is sufficient in and of itself. And therefore, there is really no need to go elaborately into what emergency processes are. The NCIA rules have emergency processes. So should parties opt for an emergency procedure or emergency arbitration, then they adopt the NCIA rules, then those will kick in, the timelines will be defined, parties will have to then be guided by those timelines. Daniel, we gave you 1 minute after you. Thank you.
You have 30 seconds to finish that thought.
No, that's fine. I think I can leave it at that. I can see it's generating a lot of interest. So
thank you, Bwana CEO. The last question, and this is a general question that I would ask in the interest of time, because it seems from the bill as is, we can be here until 6. But for today, the last question that I would ask to each of the panelists, and we'll have 1 minute for them to respond before we go to the plenary, is assuming the bill were to be passed as is currently drafted, if we were to reconvene 3 years from today, what specific section of this amended act would you point to as having actually changed outcomes for a party and all stakeholders in arbitration in this room, and what would still be missing from the act to date? I will start with you, Daktari.
I think the one on third-party funding is something that we wrestled with in terms of how do you define it. I see that to be a matter that I think Parliament will need to then address with finality, because there were really differing views on it. So I'd be happy to see what comes out of that process. But I think the other concerns that have been raised, I believe 3 years later, we would have really gained traction in terms of enhancing the space of ADR. So that's what I can say. Thank you.
Thank you. Thank you. We go to Mr. Mwaniki.
Yes, thank you. I would stay with that part of funding. As I said earlier, I have my concerns on on the proposed 39A1. Is it 39A1A? So that definitely may be an issue a few years down the line, but also would be curious as to the timelines, the very strict timelines that we have discussed that have been proposed in the bill, because I'm seeing a scenario where, like you pointed out, we'll get a challenge like we are getting with the small claims court. My proposal would have been that for the parties, it would be good to give timelines so that you are sure the process is moving forward. But for the arbitrator and probably the arbitral court, there may need to be some discretion, maybe not open discretion, but some little room for discretion, because then one would ask if the bill as it is now is passed into law and there's provision for 30 days, what happens on the 31st day? Does it mean that whatever decision is made on the 31st day then, it becomes stale? Can a party then move and say there was no jurisdiction? So that is a concern, and it's a space you would want to look at a few years to come. But the last concern I have is in apparent gaps in the bill as it is, some which may be viewed as critical, others a little contradictory. I think I mentioned again section 9A, 1A, and that 9 and B, where it talks about expected returns. So those ones then will, if it is passed as it is, there will be a concern going forward as to how the practitioners or generally the users of arbitration will be dealing with those gaps. So in my view is that before it goes forward, there may be need to do an audit of how the drafting was made and maybe rearrange some of those discrepancies and contradictions. Thank you.
Thank you, Samuel. At this point, let's go and hear from the judge.
What I would like to see within the 3 years is the issue of when somebody questions and goes to the arbitral tribunal, it says there will be no stay of, there will be, the proceedings will not be stayed. At the moment, whenever somebody challenges the arbitrator, there's no need. The arbitrator can still continue on, but will not deliver the arbitration. I would see probably in that particular concept, there might be challenges unless the parties are going to stick to the timelines that are there. I would agree with Mr. Mwaniki on the issue of the timelines. It's important that the timelines are put in place, but there is that concept that he also has brought up, that these timelines should not be bound on the arbitrator, so to speak. I would also look and see what I would probably question within a few years is the issue of that section 35 that will be there, and then the issue of the appeals. I think that will probably cause an issue. But if everybody falls in line with the particular act. And then we presume that these issues should not be able to arise to cause a conflict that there is there. So thank you very much. My aspect was to the stay of proceedings, the timelines that are there, and the notices. Thank you.
Thank you, Judge. Just want to remind the participants, we are coming to the plenary. Keep sending your questions. And if you have a question that you would want to speak, just raise up your hand. We will give you an opportunity. Lastly, let us hear from Jackie.
Thank you, Dan. I think I would be most excited about the instances where the arbitral court has then been delegated to take over the functions of the High Court in terms of assisting the arbitral process in the manner that's delineated in the Act. So speaking to what my colleagues have said around timelines and the like, I would also be interested in seeing, and we didn't talk about it, possibly we didn't have enough time, but the codes of practice under section 40B, which I think has been a bone of contention around how to tame rogue practitioners, if I can use that term. So that would be an interesting one for me 3 years from now, as you say. I would be interested in seeing some elegance in the drafting. So section 19A, for example, the first subsection is unnecessary because it is replicating what has already been said in section 3A. There's no need for the repetition. In fact, for me, I would keep 19A as it is currently drafted. It is sufficient without then going into the detail that is proposed under the new section 19A. I've already talked about some of my concerns around third-party funding and emergency arbitration. I think for emergency arbitration, it's enough just to recognize that it does exist and to leave that then to party autonomy and any institutional rules that are the manifestation of that party autonomy. I would also not be too quick to introduce this cosmetic dichotomy that section 2A is attempting by then adding emergency arbitrator. An arbitrator is an arbitrator. That cosmetic dichotomy is unnecessary, irrespective of the timelines within which the arbitrator is working. Thank you, Daniel.
Thank you, Jackie. For your last comment, it seems my landed senior and your friend, Mr. Saili Malonza, seems to disagree with
I'll find him. I'll set him straight. Don't worry.
Yes, he seems to be disagreeing with your position on that, but I like the discussion so far. At this point, ladies and gentlemen, we are opening the floor to questions from the gallery. So let the questions keep coming. We will answer them as they go. I'm seeing the first question that is coming from the participants is, and I think I will pose this question to Mr. Mwaniki, Samuel. Can someone enlighten us more about third-party funding? I think I'm going to give you 2 minutes so that you just tell us, generally speaking, what is third-party funding for those maybe on the platform who do not understand the concept.
Okay, I don't know how to do justice to the topic of that part of funding. I may not even take 2 minutes. I think we have discussed a little bit of the characteristics of that party funding. This is where a third party comes in through an agreement with the party. Commercial disputes, especially in some areas like in construction and in some big projects, they can be extremely expensive, more so for international practitioners. So that's why now a third party then comes in and funds the process. In few words, it is an arrangement between the third party, which is a third party funder, and the party for the third party to fund the process. I don't know which other words I would use really. To fund the process, the expensive dispute resolution process in arbitration. International arbitration, especially for such projects, for such disputes, can be quite expensive. And then now they get into an arrangement where they even get, they put down that arrangement on paper. And at the conclusion of the normal practice, and that's why we were saying we have a concern with the drafting in the bill. The normal practice really is that it is usually contingency based, so that at the conclusion of the dispute, then the third party gains from the award to such an amount as may be agreed. Sometimes a percentage, actually usually a percentage, but sometimes even an amount that is predetermined. I think that's in brief what I can say about that party funding. Of course, there is more discussion on the nitty-gritties that we can discuss, but maybe there's not the time and place.
Thank you, Sam, for that. I think that offers an insight, and the person who has asked that, and also our members, there's a lot of publication and a lot of conference material that we've had surrounding, generally the issue of third-party funding. There's also a message that a question that has been sent to me, and this specifically is addressed to Jackie, although she's not the one who spoke about it, but I'm sure she is able to answer it. And the question asks is, if you are drafting an arbitration clause for a Kenya-seated deal this month, does the loss of the old fixed deemed received on the day of transmission rule in the new section 9 change how you would draft your notice clause? I think generally that is the question that we talked about on how a notice then should appear under the proposed section 9, but Jackie, you can give it a go.
Can you please repeat the question? Just the question. If I was drafting?
If you're drafting an arbitration clause for Kenyan seated deal this month, does the loss of the old fixed into bracket deemed received on the day of transmission rule in the new section 9 change how you would draft your notice clause?
No. And I think the short answer to that question, in any commercial agreement that you are drafting, you will be envisioning your notices under the current dispensation, if you will. So you will take that into account. I myself am not clear on what the new act is suggesting, and that is why my quick answer is no. And remember that Section 9, as is currently drafted, and I believe Section 9A, are what we call non-mandatory provisions, which means you can opt out of it as parties. It is not a shall, it is a may. So I would go by whatever the parties have agreed in terms of timelines in the underlying commercial agreement without being too fussed about what the statute may interpret, because it is a non-mandatory provision. I hope that answers the question.
Thank you, Jackie, for that. There is also another question, and this one is posed to the judge. Although again, she also is not the one who handled that part, but I'm sure she can give us her views. And the question is, should parties currently drafting contracts at the moment wait for the bill, or should they start adapting their arbitration clauses now?
Thank you very much for that question. You should always wait for the bill to pass. The bill is not a bill. It's not an act until it is passed. So you need to wait. Although you could have it in mind, you could start working towards it if you perchance perceive, but by the time you enter into that agreement, your agreement would have been covered by the act that has been passed. But you should always just continue on with the old section until the time comes, because they'll tell you once a bill has been passed that this bill will come into effect as of a particular date. And usually that date will be at the time you look on how your clause has been entered into.
Thank you. Thank you, Judge. There's another question on the as well that has been asked, and I will pose this to the CEO. Can an arbitrator consider the costs of a third-party funder when considering the quantum of costs to a successful party they funded? And if so, I think first let us answer that part. Then, because it seems it's a two-part question, then we can go to the next part. Can an arbitrator consider the costs of a third-party funder when considering the quantum of costs to a successful party they funded?
Okay, that's a good question. So what is anticipated in the bill is that there will be sufficient disclosure that there is a third party, and this is the extent to which the third party is being involved in the process. So can an arbitrator consider that? Ideally, arbitrator, for example, in institutional arbitration, will consider what the rules provide for in terms of what you should award, whether it is costs, whether it is cost, whatever type of cost you're looking at. The arbitrator should be guided by those rules, and not necessarily the idea that there is a third party who is funding or helping. So the short answer is, I don't think so. They should follow what the rules say. In the absence of rules now, what is agreed upon by parties.
Thank you, CEO, for that. The second part of the question, I will pose it to Samuel. If the position is actually true, that an arbitrator can consider cost to a third party, then the second part of the question is, if so, given that the third party upsides are, apologies, let me just take it again. So if the arbitrator can in fact award these costs, then does allowing such costs of quantum to a successful party are they not unfair to the losing party, noting that they had not consented to the use of a third party funder in the first place?
I would say the answer turns on what Dr. Morege has said, because then your question becomes moot. Third-party funding is generally a commercial arrangement between the third party, the third party, and the party, the party in the dispute. It is. Except now the Act seems to give some provision where there will be instances, which again I have a concern with. There are instances where the Act, the bill, or rather the bill proposes that the agreement at one time can even be demanded by the arbitral court. Generally speaking, this is a commercial arrangement between the third party and the party, the third party funder and the party to the dispute. So that, strictly speaking, the arbitral tribunal need not get the details of that arrangement. They may get the details regarding the risk involved. Who is the funder? Does the funder have capacity? Is the funding illicit or not? Those details may be presented to the arbitral tribunal for the purpose of ensuring that there is the process is not loaded with irregularities and illegalities. But as to the nitty-gritties regarding what amount and all that need not be brought to the fore. Because really, when you look at it critically, it really has no bearing to the process. As we know, it costs in arbitration is is the parties' representatives cost, the cost of the process of arbitration, and then the cost of the arbitral tribunal. That has nothing absolutely to do with what funding that the party to the dispute has gotten from that party further. So in my view, again, I would say the question is moot in light of what Dr. Murege explained.
Thank you, Samuel. Although we would have appreciated your views if the answer was to the court was in the positive, but we are well guided. Thank you for contributing to that the debate.
I think I've explained that the tribunal need not know the details about what, because again, that may also have a bearing on the partiality of that tribunal. I see a scenario where the tribunal will now probably, maybe it may appear like a stretch, but you can see a tribunal which knows that a certain amount has been, expended in towards funding the dispute. Then it may be inclined to, condition or, when it comes to costs, that will be at the back of the tribunal. So I would even frown against having the tribunal know the amount of funding and the details about that. But the bottom line is really, the fact is, this really is a commercial and private arrangement. I don't see the place of it as regarding the tribunal. And I think that is where I also think the post bill may have had an overreach. In fact, I don't see its place in the dispute resolution. I am trying to place it in the dispute resolution, and frankly, I can't see. What I can see is that there may be need to identify what is the nature of that funding. But as to the nitty-gritties and the amounts and all that, I don't think that's really, in my view, I don't think it's necessary. So I am going back to the answer.
Thank you. Thank you. It seems there are so many questions surrounding the issue of third-party funding, and there is also one that is directed to the judge. And the person simply asks, what would you advise a funded client today if you were counsel?
Is that question to me on what I would advise?
Yes, Judge.
I would advise they go for it. They go for third-party funding, simply because, yes, it is expensive. Yes? Is that what the question was? You seem to be frowning.
Judge, that is exactly the question. What would you advise a funded client today if you were their advocate? Yes,
if I was their advocate, I would agree that they should go for third-party funding. And because basically the issue is not money, the issue is the truth. What exactly is the truth do you want from your dispute? And if I don't have enough money to be able to fund that process, then I'll be denied justice. But here you have somebody who's willing to fund you so that you are able to come to the truth, to come to, if you lose the case or if you win the case, to come to a situation where it has been done to its best ability. So I would actually advise, go for the third-party funding. What you want is the truth from the whole process.
Thank you. The second last question that I have from the participants, and this is for the CEO, and I think it's a follow-up to the questions we had on Singapore and Hong Kong. They ask the question, under the bill, what would make a party choose Nairobi as its preferred seat rather than Kigali, Johannesburg, Cairo, London, or another seat? In short, Is the bill enough to make Nairobi a serious continental arbitration hub, or is the problem bigger than the legislation?
Thank you. Thank you for that question. I think the consideration for what will a party choose is informed by several factors. And I think the bill or the proposed legislative intervention seeks to enhance the place of Nairobi as a seat in terms of offering certainty and clarity. However, that's not the only consideration. Other considerations go into play. For instance, what is the quality of arbitrators that are going to sit and determine the matter? What are the rules saying? What are the timelines? What are the costs? Those are things that I think would inform the party's choice and preference for arbitration. Now, when you look at the institutions you've mentioned, South Africa, you've talked about Kigali. If you look at, for example, those other institutions vis-a-vis Nairobi, what immediately comes to mind is then what are the comparatives? How would do? Sorry, how would you compare this? And I think Nairobi stands at a very strategic place to offer the assurance and the comfort that the process is done. NCIA. Top-notch. They have these rules that are very clear on what is to be done at what point. Case clearance rate, that's another thing that parties would look at. What is the type of workload that the center has had to deal with? I think if you look at South Africa, for example, South Africa, the South Africa Association, Arbitration Association, they have been around for a little longer than perhaps NCIA, and they have grown in terms of the numbers and the volumes of what they handle. But it largely feeds into the ecosystem within that jurisdiction. So I think as a country, and all of us here, NCIA is our institution. It's a Kenyan institution that we then need to embrace and look at how to grow it. There is a lot of attention, especially on Nairobi, because of its strategic position for many reasons, including the connectivity within the region, the infrastructure, the culture of this country, the strategic partnerships that it has. So there's a lot of attention and a lot of other reasons other than the proposed amendments only. They are a very welcome and needed addition to then enhance and project NCIA and even Nairobi and generally Kenya as a place where arbitration is done in a much more proficient and much more efficient way. Thank you, Daniel.
Thank you, CEO, for that. The last question, and I think this I will pose it to Jackie. Someone asks, is the bill proposing a solution, then looking for the problem?
Okay, and I'll take that probably with the question we haven't answered, which is the one after that, not after that, but somewhere later down around arbitration was intended as an alternative way of resolving disputes away from courts, and now this alternative is being pulled into the court system inadvertently by this bill. So that latter question, Sandra, I think the bill is actually attempting to address instances where arbitration has inadvertently found its way into the court system, simply because parties have challenged an award, and therefore the door has been opened for the parties to seek redress through the court system. So in a way, the bill is now seeking to address those instances, and they're limited instances. Actually, when you read the Act, you see there are limited grounds for setting aside. Even with this attempted expansion under the bill, it is very limited intervention, even in seeking the leave of the Court of Appeal to continue beyond the High Court. So the attempt is actually the reverse of the question posed, which is, we have arbitration, it's a private process, but in that process, a question has arisen which has to be addressed by the courts. Typically very grave questions around process and around questions of law. The question that was actually posed then, is the bill proposing a solution, then looking for the problem? No. The bill is addressing, perhaps in addition to what I've just said, questions around, and this next answer is limited to the instances where the arbitral court is replacing the High Court in the bill, questions around the expediency and efficiency. So, and I had seen a similar comment around, is the arbitral court then taking over the role of the arbitral tribunal? And I really encourage everyone not to look at this bill without also looking at the NCIA Act and then the role of the arbitral court under the NCIA Act. You will see it as a very limited role, and it is really to intervene in certain areas. You have a question around some misconduct, if you will, on the part of the arbitrator and the arbitral tribunal, you can put that question to the court. So there are limited instances where the arbitral court also will interfere with the arbitral process. And all these instances where either the arbitral court is coming in, or the High Court, the Court of Appeal, etc. are coming in at the instance of one of the parties. It is not as if these entities or these institutions will come in to a process that is largely private and party driven. I think the bill is attempting to balance that party autonomy with the overall efficiency and expediency that was envisioned when Kenya, first of all, assented to the New York Convention, and also more recently in 2010 adopted Article 159(2)(c) of the Constitution, and said, in addition to the court process, we have these ADR processes. So the courts are encouraged. The beauty of it is that once a matter finds its way into the courts do respect what may have transpired up to that point in terms of arbitration. So the courts, in my particular view, do not necessarily take over or even attempt to revise decisions. They limit their interaction to the extent that has been envisioned in the current act. So very long answers to 3 questions and comments that I saw, just to say that there's a delineation or a limitation or a ring fencing, if you will, of where courts intervene, where the arbitral court intervenes at the instance of the parties, and then why they do so. Daniel.
Thank you so much, Jackie, and to all our panelists. There's just one question that I've seen from a student, which might not be related to the topic of discussion, but I think it's important as part of mentorship to perhaps give an answer to the student. And this time I will ask the CEO to just perhaps answer this question to the student in 30 seconds. And the question is arbitration a fun and interesting specialization to begin with as a law student? That would be the last question. Dr.
Yeah, I think it's Ethan who has asked that question. That's a very good question. First of all, I think finding your way into this discussion, I know many things have been flying around and you really can't follow the conversation. I get that. But arbitration, yes, is a fun, if you would, a fun and interesting area of practice because it offers an opportunity for you to be able to assist parties who do not necessarily want to be dragged into court or into long-winded processes. So arbitration offers a platform where parties then can determine, they have that immediate agency of determining how their dispute will be resolved. Arbitration is good. So I think there are many ways we could introduce you to ADR, but the idea is it's a good place. And there are so many areas: international arbitration, sport arbitration, investment arbitration. I mean, it's the landscape is so huge. You would be surprised to learn that there's a lot in this space of arbitration. Thank you, Ethan, for the question, and I hope you join us, this community of ADR. Thank you.
Thank you, CEO, for that. Ladies and gentlemen, at this juncture, we have to end the webinar. We thank you for your audience. We thank you for tuning in. I thank all our panelists for being part of the conversation. We hope this is the beginning or continuation of a beautiful discussion that will perhaps lead to formulation of a better and of a better bill, that will actually serve us within the arbitration space and commercial users of arbitration in general. So at this point, that would be it from our point, from us. And I would like to invite the CEO to take it over from this point. Madam CEO of the Chartered Institute this time round.